like us to go first? We only have really the items of conflict. We don't have a lot to say about those. We could get that wrapped up pretty quick if you like.
Well, I think we have a response to the bundles, so we can do that first, and then jump into yours.
Okay, so you need to go to your side now?
Yes.
Okay.
So on this article, we don't really see that it's legitimately connected to other articles. We see it as a standalone. What we propose to put in here, we think, is a clear statement of what the law is. I think both of us pretty much accept and recognize that. So it's not really a trade in any sense, and so we would ask you to reevaluate that, think about setting it aside. And then let's go to 4 and go through them in that order. I don't know what
Sure.
order you have.
Yeah, 4.
So on management rights, as I said last time, we appreciate the fact that you thought through what we had talked about. We're willing to accept some of those. We still don't understand what the reasons are behind language that we think is inherently in the nature of the original article as it was written years ago. It appears, and I think you articulated this to some degree the other day, and I apologize that I don't remember the specific context. You did say that in connection with some work schedules, you felt like there might be a past practice. Y'all were trying to look at that. You didn't want to give it up by changes in this article, is the way I understood what you said.
I said it's a little different.
Okay, and so I'll let you clarify that in a minute.
Sure.
But we just wanted to reiterate that under this article, at the very top in the first sentence, it says, after the city's retention clause, except as specifically provided in this agreement. Well, those specific provisions include the maintenance of standards article that we'll be talking about as a part of this bundle. They include a past practice. If there is a past practice that's in effect, it's a part of this agreement. And so it's already an exception to the retention of rights under this article. So
That's true.
I will respectfully say, I think you're overthinking our proposed changes. They are much more forthright and transparent than I'm afraid that you feel like they are. We're not trying to take something back. We're not looking at this and saying, well, we should have included this and we didn't, and now we want to. We just believe that the way we have added to this definition is consistent with what it said before. For instance, at the top, the very first one, right to hire, train, promote, demote, right to discipline, suspend, and so forth. Well, those are rights that the city has as a part of the right to hire. They are subject to everything that's in the contract, and the disciplinary article and the promotions article that we write, and the article, if we have one on demotions and how that would work, like for instance, our probationary promotional provision that we put on the table. So I don't think the language that we are proposing as clarification is taking anything away. And so we'd like you to think about that, see if we can get there on most, if not all of those, and if there are any particular concerns, like for instance the one that you alluded to the other day, we can either talk specifically about those, or we can make sure that whatever you're worried about is not impaired by what we're proposing. So we don't think this article is in a posture to be a trade yet. It may well get there, if you understand what I'm saying.
So can I ask you a question real quick on that?
Always.
Okay. So you don't think that the changes he proposes for management rights are any different than we do now, correct?
I believe that's correct, and I
Okay.
think that our understanding from the beginning, because when we wrote this, we deliberately tried to write it to where we were only describing what we felt like was a part of the contract to begin with.
Sure.
Is that right?
Correct.
But would you agree with me that sometimes labor and management look at an article and understand differently
Yes.
about how the article, what the article implies or means?
Yes, I do.
Okay. So, you're adding wording to try to advance your idea of what the article is from your side, your perspective side, right? We don't necessarily agree that everything you think about management rights is what we think about management rights, okay? I think that's very natural. We just stipulated that. You know, it's very likely that both sides may think what they got in the bargain is a little bit different. That's our concern. That's what we expressed to you all, okay? So we're talking about, and so the way I look at management rights, I'd love to hear the way you look at management rights, but you're right. If there's a past practice, maintenance standards pretty much covers that.
And we may argue about that, whether or not
Of course.
there is not one, and there, you may lose, we may lose, whatever.
Yeah, but it covers, if the arbitrator decides the past practice, it's pretty much addressed in maintenance standards, right? Our concern, and I'd like to know what your thoughts are, because this could help us to get further on this, is that if it's not a past practice, but it's a change between contracts on mandatory subject bargaining, management rights clears some of that up from the management side. So, management rights allows management to make changes that could be considered a mandatory subject bargaining, but you've already kind of stipulated between two parties, it's okay to do that. Do you agree that's one of the purposes or main purposes of management rights?
It is certainly a purpose of management rights, that management within its unilateral prerogatives can make changes without bargaining,
Right.
even if they would be mandatory subjects.
Yes,
I
yeah,
think
well,
that's
yeah,
what
it
you said.
could expand beyond that, but I think it's a little easier to expand beyond that. You probably wouldn't need an article then, you know.
Probably not.
Yeah, probably not. So that's our concern. We would like to assert bargaining or negotiating, we're going to talk about older things that are mandatory subject of bargaining that change. They're substantive, not just little things like you move the broom to this clause, to that clause, so we're going to follow laws, you know, nothing like that. But substantive changes of wages, benefits, working conditions, we think they're negotiable, just as they are now, between the contract period. We want to make sure that we're not agreeing to anything that impedes that. So when we're talking about changing the management rights, and you're writing those changes, and you're clarifying what you think it means, because it's concerned, because we think it might mean something a little different. And so what we did was, in good faith, we listened to your interest on that article. We went back through, we tried to give everything we could. We contemplated scenarios. Of course, we can't contemplate every scenario management might do, or the next chief might do, or what situations might allow management to respond to. So we were careful about how we did it. We tried to meet your interest to the extent we could. So I hope that helps clarify that. Now, on the item of work schedules, we weren't saying in the case of a past practice. We're saying, let's say there's a Department X has a schedule they like. We've done it for a while, but let's just say doesn't meet the level of a past practice. You know, we would like to not increase management's ability to fight that in front of an arbitrator or to negotiate that. We would like to make our case that could be negotiated too, because you're changing a working condition. Not necessarily past practice, but working condition. So when we went through management rights, those were the scenarios we were trying to make gives on, but some of them we had more concerns about.
So let me then try to extrapolate from that, because we will shortly be coming to the other contention about the duty to negotiate in good faith during the term of the agreement, which we talked about the other day. And it just occurred to me that where you're not willing to go with the scope of our original proposal on schedules of work in the context that you just described. So we have a work schedule.
I'm sorry, I'm not sure what you're referring to.
In your response on management rights, we had language in here that included modifying the methods, processes, means, and personnel by which operations would be carried out. you were not willing to accept that in the work schedule context. Is that because during the term of the agreement, if we sign this agreement and the department decides in 2 years they want to make a work schedule modification, you would want to argue that we have to negotiate that even though we're in the term of a labor agreement?
If we think that that change was substantive enough where it changes a working condition, yes, we would.
And so that's why you're opposed to the traditional zipper clause we've always had that says we don't have to renegotiate anything during the term of this contract.
I think the way you said it would be a little too broad.
Okay.
Yes.
All right.
So again.
You say it your way so I can understand.
Pardon me?
You say it your way then. Because mine is not
I think
acceptable.
that if there's things that are unconsidered in the contract from both sides, I think management rights give certain things that management can do unilaterally, even if, they're a significant change of working condition. That's why that article is so important to us. But I think there's things that are not explicitly indicated in management rights that are significant change of working condition, that mandatory subject to bargaining. We should be able to assert a claim to either negotiate or go to an arbitrator and get that settled.
Okay.
Even if it's not a past practice. Okay.
All right.
And that's why these articles are so important to us. I think they're an important deal too. Or you wouldn't be trying to clarify what you think the past practice was on management rights through additional wording. If these weren't important to you, if they really meant nothing, you wouldn't be trying to do that either. So let's just
And I'm
be
not
honest.
saying that, so.
Yeah, just to be honest on
So
both
you're
sides
not
of the table. This is an
I'm
important
trying to be that
article.
honest, because I said to begin with, our objective is to make sure that when we make this deal, that we both know what it means, what it actually means, and that we're not just putting it off for the future for an arbitrator to see who wins. We're actually trying to resolve everything we possibly can at the table to where we know what the outcomes are.
And we are too.
Good.
It's just you get down to the point where some things can change,
Right.
and they may be questions that need to be looked at
Yeah,
by both sides again.
Our objective, our mutual objective, as we have now identified, to have a contract where we actually have a meeting of the minds, will never ultimately perfectly succeed. There will be things that get missed.
I think we are. I think we've never had this many discussions on these articles. I think we're getting closer, but there's always this. I think management naturally wants to have the say on things that are not discussed at the table, and things that they innately feel within their rights, whether it's by statute, whether it's by the contract, or just their own notion of what management gets to do. And we're gonna have differences on that sometimes. I think we're getting much closer than we ever had before. And I think in the past, I don't have a good example, I was trying to think of one while you were speaking. There's been in the past where sometimes labor feels that the city is hiding behind the law when they're bargaining, and then they pop up with a change after bargaining ends, right? Now, I can't think of a good example, so maybe I'm wrong, but I certainly feel this happened before. And I think we want the same thing, that we have clarity in the contract, just like you all do, so that doesn't happen in the future. And so we're not trying to say every single thing needs to be renegotiated. We're not saying that things are explicit in management rights need to be negotiated, even if there's not a past practice. If there's not a past practice, we're saying certain items probably do if there's substantive changes of working condition, even between contracts. I hope that's makes sense to you all, whether you agree to it or not.
No, it makes sense. And I think it's just part of the constructive process of sorting through these articles here, putting them in a position to where they in fact fit into the trademark, in the sense that I get an article that, yeah, I can live with it as long as I'm getting what I need over here. And that's what we're trying to do.
And I, just sort of being so candid, and I really like that. I think it's, you said something to the effect, and I want to misquote you, that, maintenance standards kind of different than management rights. I don't think they are. I think they're very important to consider.
I didn't mean to say that.
Okay, and maybe I took it
No,
wrong.
what I meant to say at the beginning on maintenance and standards is, I believe our proposal is just a statement of what the law clearly is. And therefore, there's not something in there that either we want or you want that fits into the bargain context.
I would prefer it not be in there, so we're looking at it as a concession. I don't disagree that that's a common standard that's used as a past practice.
That's the only
But
distinction
I
I make.
prefer it
There's
not
no-
being there.
Right.
We're saying yes because we know you prefer it is in there. and that's
But
what
I'm
we're trying
afraid
to
you
do.
heard me say that management rights and maintenance and standards are not linked, and that nothing could be further from the truth.
Okay,
They are
okay.
clearly linked.
Then I
They
miss-
are the two
yeah,
pillars of any labor agreement.
Gotcha. I understand.
And you can find that in Elcory too.
And I think it's not just those two. I think entire agreement and termination agreement to an extent. And I notice y'all, I mean, looking from, and I've had members tell me this too that study these videos, y'all are being a lot more legalistic, you know, on these articles than, if that's a term, than y'all have in the past. And I understand why. You know, we're in this different environment,
That's
right?
exactly right.
And we're both kind of trying to navigate that and do the best we can for each other's side. We're trying to be fair with y'all. We're really trying to consider your interests. I think you can tell by the question we're asking at the table and the concessions we come back with. But, you know, there's certain things that give us concern on this side of the table, just like gives y'all concern. There's gonna be a point where I think we get much closer to what you were talking about, clarity. But I think that clarity can only go so far when you talk about the future. We have to set an environment where, in my opinion, the substantive changes to mandatory subjects can still be negotiated if they're not explicit in management rights. And that's, in a nutshell, gives us what concerns about making substantive changes to management rights. But still, we're listening to y'all, and we're trying to make concessions where we can, and we'll continue to do that, and I hope your side of the table will do the same to us, for us.
Right. So, on the Civil Service Commission article, we disagree with, and this was in one of the footnotes, which I think has been carried forward. Because you refer to our position as articulated at the table on 6/7/2022 about a clear conflict of interest. We don't believe that there is any clear conflict of interest. We don't believe we said that on June 7th. It would be a clear conflict of interest if the commission's lawyer were somehow collaborating with the chief's advocate in the hearing to affect the matters that are in front of the commission for determination as an administrative body. But those lawyers there for two totally different reasons, okay? We agree that it's improper for the advocate for the chief's office on the disciplinary matter to be making common cause or collaborating with the city's lawyer to get the chief's outcome. That would not be appropriate compliance with the disciplinary rules that apply to the lawyer for the commission. It's the same thing as where the Attorney General represents a state agency and at the same time has somebody advocating a position in front of that agency. City attorneys' offices have dual roles in those contexts. Some cities go outside and get an independent outside lawyer to represent the commission. San Antonio's done that for years. There's no legal requirement that they do so. We're doing our best to preserve those roles. The language that you have in your current provision says is that no city attorney acting in an advisory capacity of the commission will coordinate with any other city attorney or other city employee to persuade the commission to adopt the city's position on any matter before the commission. We agree with that if we're talking about the advocates' positions on the incident before the commission, which is, what are the facts? Is it guilty or innocent? If guilty, is the discipline disparate, or is it unjustified, or is it not sufficiently mitigated by the person's career and the other facts and whatever it may be, where the commission is going to rule on, did the rule violation occur, and if so, what is the appropriate level of discipline? Those things are off limits for the commission's lawyer. Now, on the other hand, the commission's lawyer is going to tell them about compliance with the posting requirements and the scope of their authority, which may include jurisdiction. There may be issues that come up about whether or not a case is before or after the 180-day or other limitations rule. And so, as the lawyer for the commission itself, telling them how they must comply with the law, distinct from their ruling on the merits of the case.
Right.
Okay, and so what we're trying to do is to tweak that language there, because number one, the commission's lawyer has to be able to talk to his or her supervisor or to the city attorney about advising the commission on the commission's responsibilities under the law. And so your language would mean we can't coordinate with my supervisor about what the law is for the commission in this unusual situation that just came up that we've never faced before.
Well, that's not what it says. It says you can't coordinate with them to persuade the commission to adopt the city's position. It doesn't say you can't update your supervisor.
Well, but I'm talking to my supervisor about what I'm gonna tell the commission the law is on this issue of following the law.
It doesn't say you can't do that. It just says you cannot
Because that's the way we're reading.
persuade the commission to adopt the city's position.
Okay.
I don't see why you
The
wouldn't.
city's position in front of the commission is on the case.
Okay,
The lawyer telling the commission what the law is and what their responsibilities are under the law and the scope of their jurisdiction and what the statute says about their authority as a administrative body is not persuading the commission to adopt anything. That's their client
that's fine, as long as you're not persuading the commission to adopt the city's position.
on the case.
Yes.
Okay, I think we're saying the same
Yeah.
thing, but that's our concern.
Okay.
And
Well,
so
then
that's
I
what
think
we're
you know
trying to
our
capture.
concern.
Okay.
You know, and it's, I appreciate the exchange. I understand your concern a little bit better, and I hope you understand ours.
And then last on the entire agreement, in the last time we were together, I had asked about whether or not it was your position that during the term of the agreement, that we would have to bargain on new issues that came up during the 4-year contract term or the evergreen extension. I understood you at that time to say that was not your position. Today, our discussion has actually fleshed that out some more, and we ended up with just a hypothetical situation where if we've had a prior work schedule, that prior work schedule is not a past practice that you could enforce.
If it's not, yeah. If that's the
Then
scenario.
if the department changes that work schedule and management rights does not guarantee or reserve the prerogative to change that work schedule, then you would have the ability to come in and say, this wasn't included in the contract, and therefore you have to negotiate it before you implement. That's essentially what this is for.
That's pretty close.
Okay.
And I understand what you're talking about, because I reviewed the tapes, and I kept talking about in front of an arbitrator, right? I guess I was skipping a step there, I didn't mean to, yeah.
Not at all.
So I think that in a case where it's not a past practice, and it's not explicitly defined in management rights, and it's a significant change of working condition, let's just say in this scenario, yes, we should negotiate that. And I think that if the city refused to, then we go to court or arbitrate or whatever to make sure that happens, whatever that remedy is. And I think we're talking about a very limited set of things here, but no, we would like to retain that, which we think, we just talked earlier about what you think your rights are. We think that's a right that we've always had, and it's a right we plan on retaining and exercising more in the future. So we want to, in the guise or spirit of clarity, yeah, we're disclosing that here. We want to discuss that.
Okay. So that's our feedback on that bundle.
We just have to talk about Article 30.
Yes, termination.
Yes. And so this is our proposal for 6, 7, and this is their proposal. We'll just,
Yes.
so you can compare right here. That's theirs.
Oh, okay, good.
This is our language that we originally proposed on 6, 7.
So, just explain to me really quick, would be saying that there would be a guaranteed 6-month period, is that what we're saying there, or it has to be visual still?
It would.
The current language, that we are proposing to extend has, the 30-day increments. We would continue to have the duty to bargain during any of those incremental 30 days. And that's our official proposal, carrying forward what the current contract language says. We are willing to consider doing that for a period of up to 6 months by agreement.
Visual agreement, maximum 6 months.
That's correct.
Even if both sides want to go more, we'd be restrained to 6 months.
And we are open to more than 6 months if we mutually agree. And what we're trying to preserve here is the ability to know what the framework is at that time in terms of what are the disputed issues on both sides, so that we can make the decision about whether or not it's worthwhile and whether or not we should choose to go forward beyond 6 months. To the extent that, you know, there's a balance in the voters' proposition for impasse, it should give both sides the ability to say, fine, we'll let the third party decide what the answer is. We don't want the
What third party are you referring to?
arbitration panel.
Oh, if we still have arbitration, then most of this doesn't matter, right? I think, so in clear, you know, just to be, you know, let's be forthright with each other here.
That's what I'm trying to do.
You know, first of all, before I get real forthright, we asked 3 questions about this article, very specific. You should have had enough time to answer those questions. We haven't answered those 3 questions yet on this article.
I think that we already answered it.
I don't believe so, at least not to us at the table. I haven't seen an email on that.
Yeah, we haven't
I
responded.
don't know if an email was sent.
No, we haven't responded via email. I think our intent was to talk to you about it here today. I understand your questions are, does the city have a unilateral ability to change the terms of the contract? And I think there's different scenarios, right? Does they have the unilateral ability to change the terms of the contract while we're still negotiating, while we're at impasse, while we're at arbitration? And I think each of those questions have different responses based on where we're at.
We will come back.
Let's pull up those, go
No,
through them one by one.
I wanna talk to the team about it, we'll come back and give you the answers.
Okay, so we'll just continue the discussion then, after we
Yeah,
get
and we'll
the
be,
answers.
and we'll be glad to do that.
Yeah, I think that'd be.
We're not gonna brief it or provide legal authorities and so forth, which was a part of your request, but we will answer your questions directly and explain.
Okay, well, one of the questions is about the legal authority. I hope you give us some clarity on that, so.
Well,
If you can't, you can't, but we're hoping you can, because I think that
are you
helps.
proposing to trade briefs on that? I mean, it seems premature to me to be briefing and arguing and, you know, kind of moving into the advocacy side of how that works.
Okay, well,
Not to mention the fact that there is none in Texas. And so we're all guessing.
let's then answer our questions best you can. I think that'll help us get
Good.
further on this, because as many times, we've
Right.
talked about this before, we might be thinking of something much more cynical than y'all intend, and maybe the answer to those
We
questions
don't want
will
that
help
to happen. Right.
So,
And, you know, just for context, and I think you probably know this, but, you know, I believe it's correct to say that the city of Beaumont is the only city in the state that has a fairly long history of resolution by impasse arbitration. And San Antonio has recently implemented that. The issues that you're asking us about were never litigated there. And
I think there's more than that, but you may not know this, but I'm not a trained attorney, so I may not know all the cases in Texas. I believe Port Arthur has some case law on interest arbitration.
I don't think Port Arthur has any case law on the questions that you're asking.
Yeah.
There is certainly case law.
Oh, the
about-
question I'm asking, that could be true.
Yeah, and, you know, Corpus Christi had issues that went to the courthouse, but they were not in the context of what you're asking here.
Right.
And so we have to essentially derive primarily from the cases out of Corpus Christi, over grooming standards and a traffic accident penalty model that was adopted by the chief, where the Court of Appeals said you have to look to decisions, under the National Labor Relations Act to figure out by analogy what those questions are. And none of those cases ever dealt with a voter referendum that modified the FAA procedure. And
No,
so,
I think Corpus has it in their contract, right?
Right.
Which makes it kind of imputable, and we're open to that. You don't wanna put money in arbitration contract, I think that settles every legal issue, or at least many legal issues. In fact, there's some safeguards that you can put in the contract with that would maybe even be, the city may be interested, but I don't think y'all wanna discuss that, so I'm not gonna bring it up, I just wanna
and
offer
I
it
don't
again.
know, it hasn't been put on the table, and so I wouldn't know the answer about whether we want to discuss it.
Well, I mean, we haven't put it on the table, is that what you're asking?
Well, as far as I know, that's not a proposition that I've been involved in deciding whether or not that's a yes or a no.
Yeah, we did ask that verbally, and the city signaled no. And I said, that doesn't surprise me, I'm just bringing it up. Certainly an offer we would love to work on. If we're really concerned, if our interest on the city side, if the interest on the city side is really concerned with the legality of a charter amendment, and they want to uphold the will of the voters, we can put it in the contract. And then it takes away most of the legal concerns, and we're certainly willing to work on that. And I just want to
I'm at a
mention something.
disadvantage because Devin's not here and he's the one that's dealt with it.
I'm sorry.
I'm at a disadvantage because Devin's not here and he's not ill.
Yeah, well, we'll just
He's
leave
the
it
one
at
that's
that.
dealt with that. So,
But I just wanted to mention something, because I learned more about interest arbitration as we get more involved, I'm sure you all do too. Oklahoma is interesting, because Oklahoma, every city in the state of Oklahoma has interest arbitration if they petition for it. That's the way their statute, I think every city except for three or four is what I've been told do have it. But they have an interesting provision there, which ties back to taxpayer, which I think is really interesting. And by the way, no cities have gone broke. And no one's ever exercised this provision I'm gonna tell you about, which I think is really interesting. So the provision is if the city doesn't agree with the arbitrator's ruling, they can take it to a vote of the citizens. Never been done. And so my point is, I think some people look at worst case scenarios in arbitration, could be terrible, it's gonna break the city. Oklahoma's a pretty red state, and nobody's even exercised the provision, taking arbitrary ruling to the citizens for a vote. I think sometimes we fear things that probably won't happen a little too much. And so if we didn't fear as much, and we wanted to settle legal issues, we could put it in the contract. We would absolutely be open to that. You wanna talk about something we might sign an extension on? That'd probably be it. If we need more work to do something like that. Because that would keep us both out of court and it'd give us clarity in ways that some of us feel we don't have now. So anyway, I know you can't speak to it because Devin's not here. I just wanted to give you that extra context.
right. So our perspective on this is that as long as the period of time for bargaining, whatever we either have in the contract or agree to by mutual extension is in place, then we would have the duty to continue to negotiate and hopefully reach a successful agreement.
Yeah.
Once an agreement is expired, and I'm just trying to be transparent about this, once the agreement is expired and there is no evergreen provision or extension for bargaining, then we think the obligations under the statute have been satisfied, and that there's not a duty to bargain further, and that the city can make unilateral changes.
Well, we look forward
That
to
was the
the answer to
question.
those questions, and that might help us have further discussion on this, but I appreciate that.
I think that actually did answer your question.
I think I covered them all.
Yeah.
So, but we will come back to you and give you a specific direct answer, just kind of tick those off.
Do you think we could do that today? Is that
Yes,
possible?
we'll-
Okay, great,
we'll do
great,
that.
I appreciate that. Now, I think we have,
I think I've already covered them, but let's in an organized fashion, so you can go,
Yeah.
to the video or whatever it is and see what I have to say about it.
that would be
Yeah,
super
we'll
helpful
do.
for me,
I'm not the least bit afraid of it.
Okay, yeah, we'll put them up there and we'll go through them, and I think we'll have some other commentary perhaps based on that, and maybe that'll help us progress on that article. So, thank you.
You bet. Anything further for y'all at this point?
No, I think we're gonna try to get, we come back, we're gonna have a response to discipline and, kind of our revision of the drug testing after we did. realized some of the things that we proposed probably weren't, practical in nature. So we're gonna redo that, and, I think that's it.
Very well.
Yeah.
Thank you so much.
Thank you. Oh, we'll be sending over those items we had in conflict.
Sure, and
Reconsideration.
we'll send over, what we just went over this morning.
Thank you.
questionable on whether or not she is overtime under 4-year contract. Oh.
No, somebody's asking what's for dinner. Yeah, well, that isn't good. You guys move on. Tell you, making unilateral decisions for your children versus.
You didn't go down that hall, did you?
I'm sorry?
You didn't go down that hall?
No, that sign intrigued me. I wanted to go. I follow the rules. People can catch me.
Yes, Robin here.
Like to watch these.
Oh, Becky, I did notice, if I could mention this really quickly, Article 26, I think you sent it back. Y'all didn't strike anything, but you had a footnote that we're gonna hear from Matt.
Oh, yes, our footnote was, I think, the last negotiation session, we were waiting, I think, I wasn't here, but we had asked that you get with your legal counsel on it, and so that's what we were waiting for, was if you had gotten a chance to speak with Matt on that.
Yeah, and I did talk to him, that's what I was out talking to outside, and he said that he watched the video and it was mostly about, was this impact bargaining? I think you mentioned that a couple times, and I think I've already answered that, but I'll answer it again. It's not, what we're not talking about is impact bargaining. We're not talking about any impact that we can negotiate, go to negotiate. We're talking about what we talked about previously today. The continuity bargain for mandatory substitute bargaining that are not excluded in management rights, so.
Okay.
If you need him on, but he's gonna say the same thing, so.
Right.
So, here's the questions. I think there's really just one question, as you'll see when we kind of sort through this, for us to answer. And the first one is really has two pieces. So does the city believe it has the ability to make unilateral changes to wages and working conditions after the expiration date of the contract, if we are still negotiating? Generically and generally, as I said earlier this morning, the answer to that question would be yes. I think when a contract and an evergreen period expires, I read the Texas statute and I believe that's the city of Austin's longstanding perspective that the city has the ability to unilaterally make changes in the agreement that no longer is in existence.
If we're still negotiating, or if we're not
Well,
negotiating.
That's what I'm moving to next.
Okay.
If it was over with, the answer would be yes.
Okay, so if we're not negotiating, and.
If
then
it's
the
just
answer
over
would be
with,
yes.
correct.
Okay.
Yeah, if we were still in there, if we were still under the contract, then the contract would determine if the contract was over with, whether or not we have the legal duty, I think that's what you're asking, the ability under the law to make unilateral changes, if we are still negotiating. We think that the answer is probably yes, but I want to give you an answer that's based on what I think the purpose of this inquiry is, which is you want to know what we're thinking and how we feel about this so that we can go through this process with that understanding. Okay? We're not going to take a permanent position to where we're locked into a legal argument or a case or a statutory side or something else, and you're not, and you still have the wiggle room to decide how you're gonna meet that argument in the future, whatever context or form that might be in. And I don't think that's what you're proposing. I don't think you're saying, take a legal position and you're gonna be stuck with it, because I'm gonna have you on camera and I'm gonna show that this is what you said your answer was. Because we don't have Matt's answer, we don't have Craig's answer, we don't know what your brief is gonna read. I don't think that's what this is for. I think this is so that we can understand what you believe it is and what we believe it is, so we can go forward constructively and get it
I
done.
think that's close. I don't think we're trying to get you making legal statements that we can stick it to you later on. But I do think we want to understand how you interpret the current law, so we know how to write, how we can,
Gotcha.
how we go back and forth on
Gotcha.
writing articles.
I can't imagine that if the city was still negotiating after the expiration date, trying to resolve whatever was left, that we would unilaterally make those kinds of changes. I don't think there is a legal answer. When I get to the last part, the second clause in number 1, I don't think there is a legal answer in Texas about if we are in interest arbitration under the new provision adopted by the voters, whether or not that right continues or not. Because the proposition doesn't say, the statute is silent on it. No Texas case has ever addressed that question. As I alluded to earlier, the only way you can get an answer is looking for comparable NLRB case law in other contexts, under a totally different statute. Once again, I think the answer is, if we're going forward toward interest arbitration within the time frame that we expect, which is some reasonable time, in this fall, if you should pull the trigger and go to interest arbitration to where the last date to do that is September the 11th, I don't know if interest arbitration will get taken care of under that timeline or not. In San Antonio, as you're well aware, it took longer than that. It continued.
I thought theirs was pretty quick. I thought
It was pretty quick.
About 5
It was pretty
weeks.
quick, but it wasn't that quick.
It wasn't 5 weeks, I thought it was.
Maybe.
Yeah.
Okay.
I mean, it was pretty quick.
Yeah, but in any event, I think we're saying the same thing, that we expect a fairly prompt resolution process.
I do too.
And I believe it was part of y'all's purpose in asking the voters to consider that option and do exactly that, where there was a prompt resolution about standing items and so forth. If that's what's happening, I can't imagine that the city would unilaterally try to do something in a short time period before there was a final result from interest arbitration. So I think that neither one of those last two things that you're asking about are realistic issues or risks, because I don't know why the city would do either of those things. We're either trying to make a deal with you in maintaining our relationship of trust, or we're going to have somebody else, a panel, make that decision for us. And I think making a short-term decision for a week or 2 or 3, once again, would make no sense. So I don't think those are legitimate things to be worried about. I've already told you, to the extent I can, what the nature of the legal authority that we have, tried to be transparent about what that is. I've mentioned some of those cases. Craig and Matt already know exactly the ones I'm talking about. And so the last one, I think, is really not relevant. Why would we not make the legally required continuation of status quo bargaining? That's exactly what I think we'll be doing.
Okay. So we differ a little bit, but that's not unusual, we believe, we're asking this question, we believe we could make strong arguments with current case law that you would not need, that you could not change the bargain while we're in negotiations or interest arbitration. You're not saying yes or no, really, but it seems like you're trending towards no on that, but it doesn't matter as long as we write a provision that takes care of that. I think that's the most important thing. Let me ask you this.
I agree that that's the most important.
Yeah. So let me ask you this. Let's just say that sometime in the future, the council provides permission for y'all to challenge interest arbitration award, not just interest arbitration, but the award. And so that could last, like if we look at Houston as an example, that could last years, depending on, lots of factors.
You've actually jumped to what was gonna be my next question. is whether or not you were actually looking at this in the context of the Houston scenario.
Well, yeah, I'm using Houston as an example, but I'm really looking at this
That's the only
scenario that,
It's the only one.
yeah, we have a couple of years of dispute.
Yeah, it's been more than that.
Yeah. So what's your thoughts on that?
I don't think that I have any thoughts on that. Houston, as you know, is not comparable because what they are litigating is with respect to the proposition, the pay parity argument, as opposed to an interest arbitration resolution. So I think Texas case law is quite a bit different in the context that we're talking about here with the voter proposition. It is certainly true that in the absence of a contract in Houston, Houston unilaterally went back and imposed the standards of working conditions in the Houston Fire Department, which continue to be in effect. I think they've changed maybe a couple of times during the interim while they appealed to the Court of Appeals, and now to the Supreme Court has taken place.
Did they impose that through the judicial remedy? Is that how they did that?
No.
Okay.
The city council passed a classification and benefits ordinance.
I didn't realize that. Okay. Interesting.
Yes.
That's interesting. Okay, well,
So I think that the scenario in Austin is completely different. There are two matters, as you know, that are, one of them is pending in the Supreme Court, and the other one is briefed. I think the briefing is complete in the Supreme Court. Maybe there's one more brief that's due. The second one is the pay parity question. The first one is the constitutionality of the judicial impasse procedure under the Kingsville case. That's the case I'm in.
yes. Yeah, I think the judicial remedy case is briefed before they took it up, which is not common, but not, they do that sometimes. Yeah, I think you're right.
That is correct.
And I would agree that those statutes, or the things the Supreme Court are either brought up or considering are not similar. Maybe in certain ways, but not similar in many ways to.
They may have implications and outcomes for our situation here, and they may not.
Depending on how broad things get.
Right, but they do not involve a proposition that the voters adopted to go to impasse arbitration for dispute resolution.
Right, I agree with that. Okay, well, that's
And we would like for you to.
that's helpful enough, so I appreciate it.
You're very welcome, and we would like for you to provide for Matt or Craig or whoever, what your lawyer's opinion or perspective is on these. I'm not asking for case law and citations, anything, unless they want to give them.
We provided that. We didn't provide their legal opinion, we provided the citations that we think provide the legal authority. I know Becky has one footnotes.
Okay.
That we think the authority stems from to maintain the bargain during that period. And that's really what's prompted these questions, is we provide those citations. There still seems to be some resistance to talk about it directly. Maybe that's just my perception, that's what I took it. And that's kind of what prompted these questions.
Mighty good. Did you have anything further for this point in the process? You all still working on those articles?
Yeah, we hope to get those today still.
Okay.
And I think we will, unless we run into some sort of weird debate over an item. I think we're pretty close. We should go through them.
Any further comment or whatever by us today, prior to lunchtime anyway? All right. We'll continue to work through things. We're chasing, new rabbits, armadillos and whatnot.
Are we still on the record? I did want to ask one more thing if we are.
Yes, I believe so.
Okay. So it just has to deal with some of the interplays we talked about on management rights and financial standards and those all those interplays. And the notion of what we were trying to accomplish in Article 26. And you seem to oppose some of that notion, and I just want, and you weren't here for some of the earlier sessions, you get what I'm talking about in a
Which
second.
notion do I oppose?
The notion of continual duty to bargain based on certain criteria that I discussed earlier today in the collective bargaining environment. Maybe I mistook what you said, but But it seemed like you're pushing back on the language we had a little bit in entire agreement, which contemplates the continual duty to bargain for mandatory subject bargains that, let's just say for the sake of this discussion, excluded in maintenance and standards. And I'd like to know what your thoughts are. Maybe I took it wrong, but I did want to mention that wasn't the first time we brought it up. We brought it up earlier in the session. You weren't here, to Devin and to Becky, and they seemed to acknowledge that was a thing, continue to do the bargain. And then it goes both ways. There's some commentary back and forth. It just seemed like it was not as consistent with theirs as I thought it might be. So I just wanted to clarify.
I think there may be some miscommunication or misunderstanding because historically we have had, I think it's almost been unchanged, but I'd have to go back and look and compare the zipper clauses. The entire agreement clause has been there all along before. I think the city has believed that the things that we bargained for, that were in the contract, and the past practices that, existed. Because the classic understanding and definition of Article 4 and Article 26 is management has some prerogatives that they can exercise. Those are retained or identified. Then under maintenance and standards, we have past practices that the association can enforce against the employer, even though we didn't explicitly write things in there. For instance, we don't have a schedule in the contract for dispatchers, okay? And so that's not something we explicitly said here what the schedule's going to be. But there is or may be a past practice about that or other schedules in the department. And what all the textbooks say, including the El Corey book that we quoted from in 4. The parties come to the bargaining table with the implicit understanding of the way the workforce is operating at the time of bargaining, and that we have that in our contemplation, and that we're then talking to each other about things that we want to change to be different going forward, and we have a duty to talk to each other about those things. We go forward with the things that haven't changed. So I think when you proposed to change the zipper clause, that frankly made us reevaluate, okay, what are the things in here that we are expecting to continue?
Oh, I think it probably did.
With either the prerogative to do it unilaterally or whether or not we need to agree that we will continue it on a go-forward basis in the labor agreement.
And believe it or not, we did that to not hide behind the log, so you knew what we were intending.
And I think both of us have, and that's why we did the same thing we did in Article 4, where we said, well, let's explain what we think all of the permutations of the original word are. Because when we believed that the early contract said we had the right to establish and modify schedules, we thought that included changing the schedule. Okay? And so now we have this new issue about whether or not we can in fact unilaterally change the schedule, or if we choose to do so in the future, we have to bargain for it in the future during this contract, even though we've not done that in the past. So I think that's the full understanding of what's going on here. I don't think it's any opposition or philosophy or anti-labor attitude or anything
No,
else.
I'm not saying it was. It just seemed like you were saying things a little differently than we heard earlier in the sessions. And I'm acknowledging you weren't in some of those sessions. I just bringing up that point. But I think you clarified that. So I want to give a quick example though.
And I would say that I heard nothing different from what he said, from what Becky said.
Well, we're good at clipping tapes, but we don't need to do that because I think we're going to
We know you think you're good at clipping tapes.
Yeah,
No, I think
You're a lot better than me.
Yeah, well, we can. It's an easy technique to learn. I could be happy to show you something free. But an example of this, and I try not to talk about examples. I want to debate the examples. That's why I try to keep things more like hypothetical. But the wellland division that we have agreements on that. We're trying to settle through these negotiations. Is I think a good example of what we're talking about. There's not a past practice for a wildland division. Management probably believes they have the ability to change work duties within, and I think they do, within a certain spectrum of consideration. But the wildland division was taking firefighters who were in a particular battalion that were there previously, and now telling them you have a 2-year commitment now. If you can't get out by such and such date, you have to do a lot more work than you did before, and we're not going to give you survey for it. And so we surveyed those firefighters, as you can imagine, the surveys came out quite negative to the way it was conducted. The stakeholder meetings they didn't believe were truly stakeholder meetings. And so the important part of this is not just we think that would trigger a negotiation, which we didn't do. We just filed agreements, but we're putting on notice in the future we will do on those sort of things. The important part is, I think negotiating it would have made it better. I think it would have made it better for management, employees. We wouldn't be talking about angst and people trying to get out of the battalion. There's actually a battalion chief, I understand, busting down because he's so unhappy with what's going on there. It's not just that labor's trying to assert their will, which is the first part of my point is I think in that condition we could and should, is that it actually makes for a better process in the end. And you know, most of the time. Of course, that's a matter of opinion, right? But I think most of the time it would. So that's just an example, a real life example of something happening now that we kind of contemplate. It doesn't quite fit, and I understand you can feel differently about it, it doesn't quite fit in management rights, does not fit in past practice, but it is a mandatory subject for.
All right, I appreciate that. I'll probably take a look at that controversy because I think it would be helpful to understand your framework.
And if I think it's on your side, I can make strong arguments against that. I'm just trying to give you our perspective.
Understand? All right. We thank you, and we'll be in touch about what's next today. All right?
Yeah, I think if you give us an hour and a half, we should be able to come back. Does that work for y'all?
I believe so.
Thank you.
Okay.
Good.
Wow.
On the record. So I did not put our first proposal on there. We all know we made another one before this. This is what I call a revised first proposal based on, reviewing some of the things that will work better in practice that y'all had really made agreements on with the EMS prior. So we tried to improve on that. In practice, it wouldn't work very well. So this is our attempt to go back the best we can to kind of mesh our current article, will be believed the agreement you're working on with the EMS is. And so there's not a lot, I'll send it over to you, but there's a few things I wanted to talk about. I do think we need to, and we don't have that here yet, some sort of definition or work on what reasonable suspicion is. I think that'll be not too big of a hill to get to. Firefighter will not be disciplined for the use of a medication which the firefighter has a valid prescription as defined by the state of Texas, provided the employee is using the medication in compliance with the prescription and departmental policy. When we talk about departmental policy there, I'm assuming we're meaning the policy on what reasonable suspicion is and stuff like that. We're not saying anything counter to what's in this article, because there are some, there's always been debate before, hey, we can't really do it. It's not a valid prescription because even though Texas says it is, the federal government has some violations on that. We could be violating the Workplace Free Drug Act and stuff like that. So we're not talking about policy that would take away any substantive part of this. Now, I would argue it couldn't, but I just want to make sure that was what we're talking about.
So that question is noted, and we'll get a resolution, understand what they're doing on the day.
Okay, fair enough. And I'm thinking this section D here, when we're talking about policies, is how we do it, kind of like we have now. There's a department policy that with the random drug test, no contact, you show up at this time, you do this sort of thing. That's what we're talking about here. So, and right now, and it's good, we have very few people that are brought in for reasonable suspicion testing. And right now, I think, if I'm not mistaken, I don't mean to misquote the policy, but I think you have to have an officer contact another officer. They both make observations of signs and symptoms of a person to determine whether they're impaired, and that's how they kind of establish. There might be a few other things, but that's basically how they establish reasonable suspicion and impairment. Does the department contemplate changing that in any substantive way, or is that still what we're looking at, or is that something we need to check on?
So if I could just respond to that, this is your proposal, so the department hasn't contemplated whether or not they're accepting your proposal or changing any policies at all yet. So those are kind of premature questions.
Yeah, but independently of this, we don't know if there is any revisions of that policy.
No, I understand what part of the process we're in, Sarah. I'm just asking a question I'd like an answer to regardless of what side of the table it's on. And if y'all don't know right now, that's fine. I'd just like to eventually get that answer.
I would just note that we don't think that the Fourth Amendment issue about searches for substance ought to be, wound into the question about required drug testing. We're not sure that it needs to even be in the contract, and we think the Constitution Fourth Amendment answers those questions. We can independently talk about that, but we would rather it not be a part of that requirement for the drug test, because it's a separate issue.
Okay, I understand. I appreciate that. And I just wanted to kind of talk about the philosophy of this, just kind of walk me through it. So we have a saliva test. So you have a firefighter, I guess EMS person is what it was kind of written for, but you have a firefighter on duty. And whatever, reasonable suspicion criteria you have, the person does not, they basically suspect them of being impaired. And so they bring them in for a saliva test. And let's say this particular person has a prescription for medical grade THC, but he shows hot in the saliva test. What does that mean exactly?
Give my answer later, or you already queued up for that?
If I didn't hear the question.
If we do a saliva test and somebody has a prescription for medical grade THC and they come out hot on a saliva test, what happens? Where does that go?
So it's the same as any other drug as long as they're using it in conformance with the prescription?
I'm sorry, what was that?
Same as any other drug if they're using it in accordance with the prescription.
Okay. So,
This goes back to your earlier-
so let's say they go
your
hot,
earlier
let's say they're hot for
permission.
THC, they have prescription for THC, but there was 2 officers that said they believe there's impaired on duty. What does that mean exactly at that point to that person?
Yeah, so if they're tested for reasonable suspicion and they are positive for marijuana, then that would be subject to, consideration for disciplinary action. In the EMS article, I believe that we have that it's not termination. However, I haven't looked in yours to see if that's what you're proposing as well.
Okay,
But if they're compliant with the prescription,
Well, there's separate protocols for not being impaired on the duty, on duty.
So-
You can't take, codeine and drive the fire truck in accordance with you have to do it in accordance with the prescription.
so it's just more evidence then, right? I mean,
I think
really,
it is.
I'm gonna tell you what I think I'm hearing, you tell me if I'm wrong. So really, they're being punished for the signs and symptoms that the 2 officers see, not necessarily that they were hot or not hot on the saliva test. Is that a way of looking at it or no?
Well, yeah, so that tests more than just the marijuana, so it could be if
Right,
they're
right.
under reasonable suspicion for being impaired somehow,
So
then,
it's just a piece of evidence, but the most compelling evidence in that scenario is what they observed, right?
yeah, it's a confirmatory. in
Right.
essence.
So if they took the test and they were clean on everything, that would be evidence also. They could still very well be impaired, but that'd be some evidence the person could say, hey, I wasn't impaired at least on these things, right? So I just want to make sure I understand it. So that we're not saying here that you could be suspected of impairment on duty and you take a test and just because you have a prescription doesn't matter what the test says. I mean, the punishment would be based on that you're impaired on duty based on observed behaviors, right? Okay. So the test could help you, or it's just another piece of evidence. It's not the primary reason why you're being punished.
Exactly, and as
Okay.
you were saying the other day, that's because there is no test for.
It could help
impairment, so
exonerate you if you're
it's-
clean, you could say, see, all these bad of things, something's wrong with me, I had a bad day or whatever. But it does, that's not why you're being punished. You're being punished for what they observed.
Right, and that's,
Okay.
yeah, hence the reasonable suspicion versus the random where you wouldn't necessarily
Okay.
know.
Okay, I think that answers my question. And that's what I thought, I just wanted to make sure. And that's all the questions I have.
Sounds good.
On disciplinary, I think we're making some progress on this. It's very clear you all listened to our interest from the last time and tried to make some allowances for things that are important to us, and appreciate that. So we're accepting your changes here on training. I think we're making a big concession on polygraphs. We want to make that concession for all this stuff. Part of the chain of command meeting, have some sort of training. We accepted the edits you made there. We took another stab at this and tried to make it a little more permissive in how these two actions occur. We hope you agree with us. If you don't, I hope you can make it more the way you want it rather than just striking it. But this is our attempt to, after listening to you all and trying to meet your interests. The two things are providing a list of evidence, and you know, sometimes they stopped doing video as much. I think we had an agreement, or I wouldn't say like a strong agreement, but sort of I guess it was agreement, a verbal agreement that we'd try to do video with the harassment case, because they were doing it all the time when we started making these changes. They kind of, I think, got away from practice doing video so much with PSO investigations. So we actually included, you know, other evidence that the person wants to do. The investigator would present the chain of command, but then we're basically saying the chain of command can decide whether they want to look at it all or not. And we could probably do that differently. That's what we came up with. And we would like to have in the training possibly, you know, that the chain of command should consider the evidence, unless they have reason not to or something. We could work on that. I think you know what I'm getting at. We're trying to put a stopgap in there somewhere where inappropriate things can be, you know, if somebody deems it inappropriate, it's not viewed. And the targeted harassment basically can choose somebody for pre-deliberation discussions. So we're not talking about the whole time necessarily, but for maybe the laying out of the evidence, some discussion, and then they would be excused for deliberation and vote. And I think we say, as long as the person not a witness in the investigation, one of the members chain of command. There might be some other broader things you'll want to put in that. I think we came up with a good idea on the matrix stuff. Maybe you all might find some fault in it, but I think it's good. We accepted your strikes on the fire chief for appointee misconduct. Communications with members in the chain under investigation targets alleged harassment or target harassment. We really liked, you know, especially B, we kind of like that we can train our members and tell them, recommend that, hey, you can contact the PSO and ask for updates, and that's something that's okay to do. And then just also telling the investigator they need to have periodic updates. We think it's great. I don't think we need to put the timelines and things that we had on before. I think this meets far majority of our interests. We appreciate that wording. In the matrix, here we changed it to, you know, the association president will appoint 3. We have an HR committee. HR committee has African American Firefighter Association and LULAC representatives on that. But we want to be able to, the people that are actually at that. So we'll vet this to a wide group of people to make sure everybody's represented. But we want to be able to select the 3 that are actually part of the process. And then what we're saying down here is if the chief adopts a process recommended by the majority of the committee, then we will not appeal the punishment, the amount of discipline. You know, so there's a couple ways we could do this. We could get it on the table, which I think y'all side doesn't think we can do, so that's fine. But if we did, we agreed to the table, we wouldn't challenge the punishment portion of what's given in terms of punishment. We could only then grieve or appeal whether the infraction actually occurred or not. But then we're saying that if the majority of the people do not agree in this committee that's being formed for this contract, then we would reserve the right to grieve both.
All right, I think I understand that. Any other questions?
And then we have nothing as sort of about the chief, and we just say firefighters appeals and discipline. The deviates from the adopted disciplinary matrix shall not be limited in any way. Now, other than the ways we talked about above, if it's agreed by the majority of the people, we would limit ourselves to not appealing the punishment part, just whether we may just appeal whether the fraction occurred or not. If that makes sense. So I know that's not what you wanted, but I actually think it incents us to work together, and I think if we can work together and reach agreement on that, which we promise we'll try to do in good faith, because it's advantage to us too to have certainty in this. We will say we will not appeal the discipline piece. So I hope you accept that in the spirit we tried to offer. I actually think it's a good idea, and that's it. Okay. And then let me ask you something really quick, if you don't mind, on civil service. But I think what I heard is maybe a way to get through this, and if I'm wrong, I'm wrong. Okay. But in this last sentence, that we were to unstrike it and not talk about the matter before the commission, but the case before the commission, would that be more acceptable? I'm not asking you to prove it right now, or is that heading in the right direction?
It's heading in the right direction.
Okay, very good.
Thank you very much.
Yep, thank you. And that's all we have right now. Oh, I'll just mention longevity. I really appreciate the calculations you gave us. I think that's enough information. I'm not quite as sharp on math. That used to be something run through some scenarios, but it looks like you've given us everything we need, and we'll probably discuss that next week with y'all. I appreciate that.
We'll go back and study these new articles.
I'm sorry?
We'll go back and study these new articles.
Okay, very good. You think we might be coming back to the table?
Don't think so.
Okay,
I don't think so.
I just want to cut Tim loose.
You bet. Yeah.
Yeah.
I don't think so.
You know, if we ever do that and we have to come back, we can kind of get the stuff going. Something really important.
You bet.
Definitely here to work. So.
Thank you.
Thank you.